prosecutor's office as Assistant Prosecutor King. Let you and your client both are agreeable to this matter being conducted by Zoom as an in-person hearing. You're all right with that, Mr. Miller?
Yes, sir.
All right, Mr. Miller is charged with 3 co-defendants. There's a total of 10 counts in the indictment. So Mr. Miller is charged in count 9 and 10. 1 count of aggravated trafficking and 1 count of aggravated possession. This matter was set for a plea hearing. As the court received notice that there had been a agreement reached, I do have a plea of guilty form, which is a 3-page document, Mr. Miller, that's been presented to me. Hold up the camera to show you. Recognize that there it has your case number, your name, it says plead guilty on it.
Yes, sir.
Alright, and on page 3 there are signature lines, and not quite halfway down the page, there's a sentence to read that is plea voluntarily. Below that appears to be a signature of Trell Miller, and I'll hold that up there and ask you if that's your signature right there below that sentence.
Yes, sir.
When did you sign this agreement, Mr. Miller?
I believe it was Friday.
Alright, and signed it there at the jail, I assume?
Yes, sir.
And was your attorney there to explain everything to you, go over with you before you signed it?
Yes, sir.
And did you understand when you signed it that it's agreed to plead guilty, which means it won't be a trial, the next step in your case will be a sentencing hearing?
Yes, sir.
And did you have enough time to fully consider this matter before making this decision?
I did.
And do you still want to go forward with this agreement?
Yes, sir.
And are you entering into the agreement voluntarily?
Yes, sir.
Right, now the agreement states that on page 1, you're going to plead guilty to an amended charge in count 9 of aggravated traffic methamphetamine, still the same title, and still the same section number 2925.0381. But instead of being a second-degree felony as charged, it is a third-degree felony, so it's going to be reduced by 1 degree, and that's going to be by reduction in the amount of both substance.
Yes, Your Honor.
Okay, currently he's charged with selling or offering to sell over 5 times bulk, less than 50 times, so it'd be reduced by amending that to over bulk, but less than 5 times bulk.
Yes, sir.
Okay. Alright, so what that does, Mr. Miller, is it reduces it by 1 degree of felony. Currently, as charged, a second degree felony is a mandatory prison term of at least 2 years, up to 8 years, as set by the judge. That's a mandatory minimum. There can be a maximum of up to an additional 1/2 of whatever term is imposed by the judge that the Department of Corrections could require to be served. So, worst case scenario is 8 years is the sentence for conviction on that offense. Then it could end up being as much as 12, depending upon the Department of Corrections. Now, by amending it down, by reducing the amount of the substance allegedly involved, it's a third-degree felony. Third-degree felonies are between 9 and 36 months in prison. It starts at 9, then goes to 12, and then it's every 6 months up to 36 months. Also, it's not mandatory time, so there is possibility of either community control or judicial release. So unlike F2, which is mandatory, whatever the sentence is, has to be served 100%. Now, it states on page 1 that you understand that that's maximum sentence of 36 months in prison if possible. Maximum fine is $10,000, is mandatory fine $5,000, and license suspension 6 months to 5 years. Now, the prison term is not required. It's not. There's a presumption. What that means is that the legislature said when they enacted this law that, in their view, normally a prison term would be required to recommend a sentence, but it's up to the judge, so I don't have to follow that. You understand that?
Yes, sir.
Now, are you facing any felony charges in any other jurisdiction?
No, sir. It's my first day.
Okay, so you're not on probation, community control, parole, or post-release control for a felony in any jurisdiction.
Yes, sir.
All right. Now, under the law, Mr. Miller, if you're convicted of this offense and sentenced to prison, upon completion of the prison term, the adult parole authority may, at their option, choose to put you under what's called post-release control supervision for a period of up to 2 years, which means you'll be supervised by a parole officer on the terms they set, because the court's not involved with that. If they determine during that period of time that you have failed to comply, they can return you to prison, make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of prison term for all violations. But committed a felony, an additional whatever sentence the judge in new case imposed, the judge would also sentence you for an additional period of 1 year, whatever time left on the 2 years post-release control is ever greater. If that occurred, that would have to be served consecutively the sentence in the case. You understand that?
Second.
Under the law, I'm not required to sentence people who are convicted of this offense to prison. I can't impose what's called community control or probation, which means instead of going to prison, you can put under the supervision of a probation officer for the term set in the court for a period of up to 5 years. If during that period of time the probation department felt that you were not complying, they would return you to prison. I'm sorry, if the probation department felt that you were not complying, then they would file a written notice of that in court, give you a copy, and there would be a hearing, and you'd be entitled to have an attorney at that hearing. If the outcome of that hearing was that you failed to comply, then at that time the court would revoke your control, and then sentence you to 36 months, fine with $10,000. You understand that?
Second.
Okay, so as amended, count 9 agrees that on about March 24, 2021 in this county, that a Malik Aubrey Eugene Robinson and you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance, an amount equal to or exceed 5 times bulk amount, less than 50 times bulk amount. In violation, and that's how it reads now, but that's amended to read amount equal to or exceeding bulk, but less than 5 times bulk. Violation section 29250381. So that's as amended. So that makes it the third degree felony with the penalties I just described. Now, Mr. Miller, do you understand what it is you've been charged with by the state, what they said you did with, or how they led you with it?
Yes, sir.
Do you understand the sentences for the amended charge?
Yes, sir.
Have you discussed the charge with the nature of it, the evidence of the case, possible legal issues of the case, possible defenses might try to raise a trial, and possible outcomes of the trial with your attorney?
Yes, sir.
And are you satisfied with her advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No.
Now, has any threat been made against you to plead guilty here today?
No, sir.
Now, page 2, there are several lines that are printed in bold and underlined, so I will read those now. Defendant shall enter plea guilty to count 9 as amended. State will dismiss count 10. State defense shall recommend 36 months incarceration. State will not impose judicial release of Star after 6 months incarceration. Defendant agrees to repay by money to the Loudoun County Task Force the amount of $540 joint settled with the plea Aubrey Eugene Robinson. Defendant agrees to cooperate fully in prosecution while co-defendants cooperate fully with the task force. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
All right, now, Mr. Miller, under the law, matter of sentence as well as judicial release is up to the judge. So, if I follow the recommendation and give you the 36 months, which by the way is maximum possible on the amended charge, even though the state's not opposing judicial release, no guarantee that you'll get it. I'll decide that based upon all the information presented and what's happened since you've been in prison, and as well as any background information that's available that the probation department presents to you. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that supervises any occupation or profession? In my understanding. Okay. Do you have certain constitutional rights, as I understand, for acceptably from you? Miller, first, you have the right to have counsel, as a witness appointed to represent you, not simply work the case out, but then to provide any defense that might be available to you under the law that you would like her to provide. So if you decide you don't want to plead guilty, that you want to defend against this charge and both these charges, then she'll continue to represent you, defend you, including a trial, if that's what you want. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial. 12 people will be selected from a group of citizens that are summoned for jury duty on your trial day. After they are selected, the evidence will be presented, they be instructed by the law, and that jury of 12 people will have to decide on a unanimous verdict, because all 12 have to agree whether or not the state's true or guilty. Now, if you didn't want to have a jury trial, if you didn't want to plead guilty, you can waive in writing, which means give up the right to have a jury trial. In that case, you have what's called a court bench trial, meaning that instead of the jury hearing the evidence, it would be the judge who would hear the evidence. The judge would apply the law. The judge would decide whether or not the state proved your guilt or proved guilty of that. You understand that?
Yes, sir.
Under the Constitution, Mr. Miller, you have a right to confront witnesses against you and cross-examine for your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor done asking those witnesses questions, then your attorney can ask questions. That's called cross-examination. purpose of which is to try to help your side of the case. You understand that?
Yes, sir.
Now, under the Constitution, you have the right to use the power of this court to compel reporters to come to court and testify to you, the state of the state. So what that means is that if you have witnesses you're not certain are going to come in voluntarily, at your request, court issues a court orders called a subpoena. And that would force those people to come to court and be able to testify for you if you wanted to, even though they didn't want to be here. Which is the same way the state's witnesses are forced to come into court and testify. Yes, you understand that?
Yes, sir.
Now, under the Constitution, Mr. Miller, you have a privilege against self-incrimination, which means you should not be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make the decision. If you decide not to testify, the fact that you did not testify, not to use against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. That is, if there's a jury trial and you don't testify, then the judge would instruct the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Under the Constitution, Mr. Miller, you are presumed innocent until proven guilty by the state on every essential element of this offense. What that means is that the witnesses against you, what that means is that the burden of proof isn't on you to try to show you're not guilty, simply because you've been accused and indicted. In fact, under the law, you don't have to present any evidence to defend yourself at all at trial. You may, but you're not required to. Whether you do or not, the burden of proof remains on the state of Ohio. Prove your guilt by proving beyond reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Right, now, originally entered plea of not guilty. Mr. Miller, not guilty plea, denied the allegation, denied committed the crime, and exercised all the rights that I just described. Now, if you change the plea from not guilty to guilty, that is the plea also not guilty. The guilty plea admits the allegation, in fact, it has admitted, admits that that's a crime and that you committed that crime. And that plea waives gives up all of the rights that I have just described for you here today, except your right to have an attorney. You will always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty will waive give up your right to a jury or court trial. Waive give up the right to confront witnesses against you and cross-examine for your attorney. Waive give up the right to use the power of the court to compel or force witnesses to be in court and testify for you, just like the state. Way to give up or prove against self-incrimination because you say you're guilty, so that's what you find you guilty. And Waste gives up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove that you're guilty. It also subjects you to being sentenced immediately by the court, which is what is proposed here. And then finally, Waste gives up any right to file an appeal that you think you could have up to this point in the case. Now, if you should be sentenced to maximum, well, not in this case, but under certain circumstances, you could have the right to appeal. That will have to be filed in 30 days if your sentencing is to be filed. Do you understand that?
Sir.
Now, Mr. Robinson, do you have any questions about the charge or possible penalties as amended?
No.
Okay. All right. You understand it?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
Have any questions about the constitutional rights of the court?
No, sir.
You understand those?
Yes, sir.
You have any questions about the guilty plea, what it means, what will happen if you enter that here today?
No, sir.
You understand that?
Yes, sir.
I didn't tell you this earlier, but I'll tell you now that if you would like to speak to your attorney privately, I can put you and her into a breakout room. We'll just be the two of you on the screen talking, and no one else will be able to hear you or listen to you and see you. And the deputy will say, step out of the room or whatever. Do you need to do that for anything?
No, sir.
Okay, you have any questions at all about what I'm explaining to you here today?
No, sir.
Then, Mr. Miller, is it your decision to withdraw your not guilty plea, plead guilty to the amended charge in count 9 pursuant to the terms of this written plea agreement that we just done?
Yes, sir.
All right, then as to the charge as amended, and I will make that change by name after you please. And that is that on or about March 24, 2021, in Huntington County, Ohio, Malik, Aubrey, Eugene Robinson, and you did knowingly sell or offer sell methamphetamine Schedule 2 controlled substance amount equal to exceeding bulk or less than 5 times bulk as amended. Violation of section 2925.0381, a third degree felony, carrying possible penalty of between 9 and 36 months imprisonment in increments by the law, fine of $10,000, mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, I'm changing striking out 5 times multiple amount, and then striking out 50 and 35, in the indictment initially done, and today's date is 7/18/22. All right, the court finds that on this date of the court, defendant devised all his constitutional rights, made a non-intelligent voluntary waiver of same pursuant to Rule 11, pleas accepted or filed, and is found guilty of count 9 as amended, and count 10 is dismissed. Now, there's no request for pre-sentence investigation, and the court will go ahead and proceed with sentencing at this point. So, anything from the state beyond that's already ordered? Or anything plea agreement? Okay. Ms. Whit?
Yes, Your Honor, we ask the court to follow the joint recommendation. Petro does not have any prior felony history, and only has one previous misdemeanor, and has been very upfront throughout this case. We ask the court to follow the recommendation.
All right. Miller, anything you'd like to say?
No, sir.
That's, we were arrested originally in Montgomery County, I believe. If I'm not mistaken. I have here a 40 waiver on June 4th. So, were you arrested on the 4th or what, 3rd of June?
I think it was the 6th, 7th.
According to this, you were in jail up there on the 4th.
Well, yeah, something.
Okay. I'm just trying to make sure that you get all your jail time credit. Okay. All right, well, all this is first offense. It was a very significant amount of drugs, and the charge was reduced. There is a recommendation for judicial release. So it is the judgment of the court that the defendant B and is hereby sentenced to the correctional center center for Ohio for a period of 6 months. And according to the sheriff, he has credit June 7th in our jail, which will be 41 days as of today. And Montgomery County looks like he would have been arrested on the 3rd, so that would be 4 more days, so that would be a total of 45 days of jail time credit. Now, upon completion of this prison term, Mr. Miller, it is possible Bell Parole Authority will put you in post-release control. They don't have to, but they can. If they do, you'll be supervised, then it will be for up to 2 years. And if they do, you'll be supervised on the term they set. And if they determine that you have failed to comply, then they can return you to prison until you serve the entire term absorbed by the court for an additional period of up to for 9 months or 1 violation of the maximum for half of your prison term for all violations. You could do felony water post-release control. That in addition to every sentence judge in that new case proposed upon you. That judge would also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year. Whatever time will be left on the post-release control period, whichever is greater. Factor is asked to serve consecutively the sentence in the case. You're also ordered to pay the court costs, which you have to grant an execution order. If you don't do that, then the clerk like that declaration may completely let on bank accounts, wages, earnings, other assets that you may have. That doesn't collect that upon your release from prison, not while you're in prison, once you get out. Court authority to do service, give you credit for each hour you work, and earn away that for each hour you work, reduce your judgment by that amount until paid in full. You're also ordered to pay restitution amount of $540 to the Hyde County Joint Task Force. We paid through the victim witness restitution escrow account, taking fees that are in charge of that. Now, there's been a change in your circumstances financially since I appointed counsel for you. All right, the court will find that you're not able to pay the mandatory fine. Unlikely you'll be able to do so in the future, therefore the court will waive that fine.